Ludlam. Senator Lindgren.
Thank you, Mr Acting Deputy President. I rise to speak on the Fair Work Amendment Bill 2014. This bill will deliver on key aspects of our election promises policy and does not go any further. Indeed, on union workplace access, individual flexibility arrangements and the removal of the ability to strike first and talk later, we are delivering on specific policy promises made by the Labor Party prior to the 2007 election, but which Labor deliberately broke. The Coalition's Fair Work Amendment Bill 2014 gives effect to a number of commitments in our policy and further restoring balance to the system. The bill does this by improving the process for the negotiation of Greenfield's agreement to ensure that unions can no longer frustrate bargaining for those agreements through unsustainable claims and delays, which can then threaten investment and delay commitments of major new projects that are crucial to our prosperity. Restoring union workplace access rules reflecting those in place prior to Labor's unbalanced amendments, and dealing with excessive rights of entry visits by union officials. Improving workplace productivity and flexibility by enhancing the scope for employees to make individual flexibility arrangements that meet their genuine needs as determined by their employers, those employees. Closing the strike first, talk later loophole in the good faith bargaining rules which Labor refused to address, and maintaining the value of unclaimed wages recovered for workers by the Commonwealth. This bill also enacts a number of recommendations from the Fair Work Review Panel in its 2012 report, commissioned by the now Leader of the Opposition, Mr Bill Shorten. The Fair Work Amendment Bill will address the current imbalance in union workplace access rules. Our changes will fairly and sensibly balance the right of employers to be represented in the workplace if they wish to be, with the rights of employers to go ahead with their business without unnecessary disruption. The Coalition Government sees the right of entry as a specific statutory privilege to which conditions ought to apply. Regrettably, some union bosses do not. In 2007, the Labor Party promised on multiple occasions that there would be no changes to the union right of entry laws, and this has meant that many businesses face excessive workplace visits from unions, even when their employees are not union members and have not asked for union presence. The problem has been exacerbated in some workplaces by unions competing to represent employees at the workplace. The problem was highlighted by the former government's Fair Work Review Panel, which noted that the Pluto LNG project received over 200 right of entry visits in only 3 months. BHP Billiton's Worsley alumina plant faced 676 right of entry visits in a single year. Our changes will reduce the capacity for unions to deliberately harass and disrupt businesses in this way. A recent case featuring CFMEU National President Joe McDonald has underlined the urgent need for these reforms. In the most recent case, where Mr McDonald and the CFMEU were fined $193,600, he ignored consultant requests to leave a site owned by Cytec Pacific Sino Iron Ore in Western Australia. This type of vitriol has no place in modern and fair workplaces. And to be clear, these amendments will enact Labor's publicly stated promise prior to 2007 election, a promise that was not honoured. And given that the Labor Party in opposition, with the strong support of the union movement, supported this 2007 policy platform, we expect these amendments should not be contentious. Most union officials will find these changes are not impacting their sensible approach to their right of entry activities. Currently, right of entry for discussion purposes can only occur when the relevant union is entitled to represent the industrial interests of the employees at the workplace. This means unions can enter and hold discussions even if they have no actual members at the workplace and no one has sought their presence. The bill will amend the provisions so that the ability for unions to enter a workplace is either tied to a union's recognised representative role at the workplace, or employees at the workplace have requested the union's presence. A union will only be entitled to enter a workplace for discussion purposes if they are covered by an enterprise agreement, or they have been invited by a member or employee they are entitled to represent. If the employee would like the union to come to their workplace, wishes to remain anonymous, a union will be able to apply to the Fair Work Commission for an invitation certificate. The Fair Work Commission must issue a certificate if it is satisfied that a worker who performs work on the premises and whom the union is entitled to represent has invited the union to the workplace to hold discussions. The certificate will not identify the employee who has made the request. This will restore the balance in the right of entry regime so that it is similar to prior to the commencement of the Fair Work Act, consistent with the bipartisan consensus at the time of the 2007 election. Mr Acting Deputy President, this bill will also provide effective mechanisms for Fair Work Commission to deal with disputes about excessive right of entry visits for discussion purposes. The previous government amendments to the Fair Work Act in this area were drafted in a way that renders them largely ineffective and only able to be used in extreme circumstances, where there has been an unreasonable diversion of the occupier's critical resources. These amendments will remove this restriction to ensure the Commission has the power to properly deal with the excessive right of entry visits, for example by suspending, revoking or imposing conditions on an entry permit. Additionally, the amendments provide the Fair Work Commission can take into account the combined impact of visits by all unions to the workplace, reflecting that in some circumstances an employer will be the subject to visits by multiple unions. The bill will also repeal the government's amendments made in 2013 that expand union right of entry rights even further by allowing for uninvited lunchroom invasions and requiring employers to pay for the cost of union boss joyrides to remote work sites. Those amendments give unions the rights to insist on addressing workers in their lunchroom, even when the workers have not requested their presence and are not union members. This is unfair to the 87% of private sector workers who are not union members and for all workers that just want to eat their lunch in peace. This bill will restore the sensible arrangements that were previously in place, whereby union officials must comply with a reasonable request by the employer to hold discussions in a particular room. Employers will continue to be prevented from nominating locations with the intention of intimidating, discouraging or hindering employees from participating in discussions. The former government has also introduced obligations on employers at remote work sites to provide union officials with transport and accommodation to enable them to access those sites. We repeal this costly and onerous piece of regulation and instead reinstate the previous approach where unions and employers can reach their own arrangements in these circumstances. Mr Acting Deputy President, this bill will remove the effective union veto power over Greenfield's agreements, which have enabled them to frustrate the making of these agreements by seeking exorbitant wages and conditions or refusing to agree at all. As the former government's Fair Work Review noted in somewhat understated language, these practices, and I quote, potentially threaten future investment in major projects in Australia, unquote. They have already delayed major resource projects worth billions of dollars, and this is bad for jobs and bad for the economy. The bill will extend good faith bargaining to the negotiation of Greenfield's agreement to improve standards of bargaining conduct. This will mean that employers and unions will be required to, for example, attend and participate in meetings with each other and consider and respond to proposals in a timely manner. To ensure that Greenfield's agreements can be made in a timely manner, the bill will establish a new optional 3-month negotiation timeframe. The 3-month timeframe will apply where appropriate notice is provided by an employer to the relevant union or unions. If an agreement cannot be reached in this timeframe, the employers will be able to take its proposed agreement to the Fair Work Commission for approval. The agreement will have to satisfy the existing approval requirements under the Fair Work Act, including the Better Off Overall test. The agreement will also have to satisfy a new requirement that it provides for pay and conditions that are consistent with the prevailing standards within the relevant industry for equivalent work. Consistent with the existing framework, the Fair Work Commission must also be satisfied that union or unions to be covered by the agreement are able to represent the majority of future employees. The amendments of the Greenfields provisions will help to unlock new investment and prevent needless delays to new projects. And this will provide confidence and certainty to investors and ensure that Australia and Australians benefit from the prosperity generated by these new projects. These amendments will send a strong message to overseas investors that Australia is open for business and that projects can get underway quickly. The bill will revoke the strike first, talk later loophole under the Fair Work Act, consistent with the promises of the Labor Party prior to the 2007 election and the recommendations of the Fair Work Review Panel. And in his speech to the National Press Club of 17 April 2007, the then Labor leader said, "Industrial disputes are serious. They hurt workers, they hurt business, they hurt families and communities, and they certainly hurt the economy. The employees will not be able to strike unless there is genuine good faith bargaining." This is not the case under the Fair Work Act, where employees are allowed to strike before bargaining has even commenced. The bill will amend the Fair Work Act to provide that protected industrial action can only be taken if bargaining for a proposed agreement has commenced. This amendment will mean that industrial action cannot be the first step in the bargaining process, restoring a balanced and harmonious approach to enterprise bargaining. The Coalition will fix this loophole, and in doing so, Labor's 2007 promise will finally be implemented. The bill introduces amendments to provide clarity and certainty for employees around the use of individual flexibility arrangements. IFAs are an important tool introduced by Labor with the intent of enabling workers and their employers to mutually agree on conditions that suit their needs, while ensuring that employees are better off overall compared to their underpinning employment instrument. IFAs ought to be an important option to enable employees to, for instance, manage their childcare or other caring arrangements, to spend time with family or other commitments. They are specific to individuals and not designed as a management tool for business. These amendments about IFAs are based on the Fair Work Review Panel recommendations. They also include further new safeguards to ensure that employees are better off. To be clear, the current IFA framework in the Fair Work Act will stay with additional protections in place, and this means that an employer cannot force an employee to sign an IFA or make it a condition of employment. The employee must be better off overall than it would have been under the applicable modern award or enterprise agreement. A worker must provide a statement to the employer saying that the IFA meets their genuine needs and that they are better off overall. Under the current system, unions can restrict the scope of flexibility terms under the enterprise agreements through the bargaining process to only cover a single matter, for instance, the taking of leave. This means that workers may be denied the chance to have IFAs on other matters, even if they and their employer want to agree to more suitable arrangements. The amendments will deliver on promises made by Labor in 2007 and provide that IFAs may be made in relation to all of the matters currently prescribed in the model flexibility term, to the extent that these matters are covered in the agreement. This will ensure that workers have access to fair flexibility without veto by union bosses. The bill also implements the Fair Work Review Panel recommendation that employees should, in limited circumstances, have a legal defence if they enter into an IFA in good faith, believing it meets all the requirements of the legislation when it turns out later it doesn't. The defence will only apply where the employer believes on reasonable grounds that all statutory requirements have been met in relation to the IFA. The bill will also strengthen protections for employees by requiring a statement setting out the arrangement meets their genuine needs and results in them better off overall. And this will make the position absolutely clear. Employees will only make IFAs that provide non-monetary benefits when the employees themselves make a clear statement in writing why they are better off overall. Two further amendments recommended by the Fair Work Review Panel will be made to provide clarity and certainty to both employers and employees. First, the unilateral termination period for IFAs made under enterprise agreements will be extended from 28 days to 13 weeks, consistent with the position for awards. In addition, 13-week unilateral termination period for both modern awards and enterprise agreements will be placed in the legislation. The second amendment will confirm those existing positions that the better off overall test for IFAs can be satisfied by exchanging monetary benefits for benefits that are not monetary. This is already the case under legislation as introduced by the Labor Party that operated while the Leader of the Opposition was the Workplace Relations Minister. And this position has been confirmed by the Independent Fair Work Ombudsman. The amendment, combined with the government's new requirement for a statement in writing from the employee, will provide greater protection and certainty for all parties. All other rules relating to the IFAs will be retained, including that they cannot be made a condition of employment, must leave the employee better off overall, and must be genuinely agreed to. Anyone who opposes these amendments needs to explain to the Australian workers why they should not have the opportunity to be better off overall, and if these arrangements generally meet their needs as assessed by themselves. The bill will also implement a number of other common-sense recommendations that were made by the now Leader of Opposition's Fair Work Review Panel in 2012, but not implemented by the previous government. The bill will clarify the interaction between leave and workers' compensation by removing an exception that allows employees in a few jurisdictions to accrue or take leave while absent from work receiving workers' compensation. This will remove inconsistencies and confusion that currently exist for employees and employers and ensure that employees on workers' compensation across the country are treated consistently. In line with the Fair Work Review Panel's recommendation, the bill will clarify the circumstances where annual leave loading is payable when a person leaves their job. The change will restore the long-standing position that employers are only entitled to annual leave loading when their employment ends if it is expressly provided for in their award or workplace agreement. This will address the confusion that currently exists as a result of the legislation and numerous awards adopting different positions. It will still allow for annual leave loading to be paid, including after employment has ended, and it is in the employee's modern award or enterprise bargaining agreement. The bill will introduce a requirement that an employer must give an employee who has requested to extend their unpaid parental leave a reasonable opportunity to discuss their request unless the employer has already agreed to the request. And to be clear, this discussion does not need to be face-to-face but can occur by other means, for example a teleconference or a video conference. The bill will make changes to the transfer of business rules to assist transfer of employees who wish to move between associated entities or voluntarily. Currently, if an employee wants to take on a new position with an associated entity of his or her employer, there needs to be an application to the Fair Work Commission to prevent the employee's industrial instrument transferring with them. Under the changes, the terms and conditions of the employment at the new employer will automatically apply to an employee transferring between associated entities on their own initiative. This change will reduce red tape for employees and employers in such circumstances. In line with the recommendation of the Fair Work Act Review Panel, the bill will give the Fair Work Commission clear powers to dismiss unfair dismissal proceedings on the papers without conducting a conference or hearing in certain circumstances, such as where an applicant fails to attend a conference or hearing or fails to comply with an order or direction made by the Commission. The bill includes safeguards to ensure procedural fairness for the parties before the matters can be dismissed, and this will help prevent employers incurring unnecessary costs in defending a claim that is not being seriously pursued by the applicant.
Thank you, Senator.
Sorry, I'm not finished. I'm just flicking through the pages. The AC2, the Greenfields Agreement in this bill will allow prospective employers and unions to negotiate terms and agreements prior to the commencement of genuine enterprise agreements. Why is this opposed? Perhaps it's the requirement to start in good faith, not to come in seeking the very payments that we are hearing about now. Currently, as unions are in the position to withhold any agreement prior to the new project commencing. Although it is quite clear, as we are hearing from the Hayden inquiry, that the Honourable Bill Shorten and the CFMU have developed a technique to help along new enterprises. So what's wrong with the Greenfields Agreement? It allows work. So what is so wrong with the Greenfields Agreement? It allows both workers and employers to know in advance of a project starting of the terms and conditions. The workers will know what their entitlements are prior to accepting employment. The employers can forward plan and everybody benefits. If a union is truly concerned for their members, why would they be happy for them to walk into unknown set of conditions? Mr. President, I commend this bill to the House.